And welcome back. Still heading on with our discussion here in studio. So you've heard what the EU ambassadors talked about, the justice system in the country. And on that note, without justice, nothing can happen. And that is why I have got two brilliant heads in studio. I have got Syokau, who is a lawyer and a certified arbitrator and mediator. I have got Dr. Wilfred Mutubwa, who is chartered arbitrator and chairman of CIArb Kenya. They want us to talk about matters mediation and arbitration in Kenya as a way of dispute resolution. Welcome to the program.
Thank you very much.
Let me start with the lady next to me. We have got a lot of cases still pending in our justice system. And many people still go to courts looking for justice over and over and over again. How expensive is justice in Kenya, to start with?
Let me start by saying that justice delayed is justice denied. For the long time, I think since the Constitution in 2010,
yes,
we've had so many cases whereby we find many people don't get to resolve their issues because of the pending cases that are in the judiciary.
Right.
However, through the Constitution, Article 159 allows us to have alternative dispute resolutions. And through the help of the judiciary, we have now the court-annexed mediation, which we are able right now to assist Kenyans to be able to solve their conflicts for a shorter time.
Right.
Yes.
Has that been, just to come to you, Dr., has that been easily embraced by Kenyans, ADR, in terms of dispute resolution? Has it been embraced largely by Kenyans?
Thank you very much. And first, let me thank you for having me here today. I want to begin by saying that the justice system is an entire ecosystem. It is not just about the courts. There will be no time at all when the courts will be sufficient in resolving our disputes. To answer your question, whether Kenyans have embraced alternative dispute resolution, in fact, if you asked me, Kenyans rely on alternative dispute resolution on a day-to-day basis to resolve their disputes. It is only in exceptional cases that people go to court. In fact, the research we conducted last year at the Chartered Institute of Arbitrators, and I have the privilege of being the chairman of the Chartered Institute and serving on the task force that rolled out the court-annexed mediation in the judiciary. It's a task force led by Justice Ochieng. We have been around for about 8 years. What we noticed is that about 92% of disputes in this country are resolved by alternative justice systems. Only about 8% of cases are resolved in court.
92 is a big number.
And that 8% is what you are now saying has created a backlog. Imagine if the justice system, with all its financing from the state, can only carry 8% of our disputes and still be overwhelmed. What is it that the ADR sector is doing? The ADR sector is actually the driver of justice in this country. It is what carries the load, the alternative justice system itself. So what has happened, and what my sister was talking about, is the recognition of the ADR within the formal justice system, so that the courts are now giving impetus, giving access and assisting it. Now, this is a matter which, as my sister has said, is not a question of an option. Kenyans in the Constitution of 2010 commanded the judicial system to promote and actively ensure that ADR is used in resolving disputes.
Right. But even as that is happening, one would argue that the sensitization bit of it is what is lacking, probably.
I believe that the Kenyans have not had enough education and they've not been enlightened on the benefits of mediation and arbitration. To start with, most people really don't know in mediation it takes a very short time compared to going to court. Because going to court at times it might take 24 months, maybe more. However, if you are mediating an issue or any case in mediation, it takes to around either 66 days or 60 days. And having the benefit to be able to complete a case in a very short time,
yes.
It means an individual is able to continue on with their lives. Because I believe most cases are more emotional rather than having to head to court, whereby you'll have to take a very long time and it becomes strenuous for an individual as well.
Yes.
So in mediation, it becomes shorter, and also in mediation, things are a bit calm. And like when going to court, it becomes a bit hectic because many people are not really comfortable going to court. It's public, but in mediation, it's a private session where you're having your mediator. It becomes a very easy way to resolve your conflict.
But you see, when you talk about mediation, it sometimes becomes a win-win situation. And most of these cases are either domestic, civil cases, that would actually include even the local administrators like the chiefs, we have the elders, and even now the professionals sitting around and mediating about these cases. But if you look at it this way, at what particular point will Kenyans start to appreciate the fact that we have got a mediation as ADR, and leave alone the court cases, the court process? Because the backlog of cases will always be there. But until we embrace the aspect of ADR, then we'll always be running to courts, having in mind that that's where justice is. Doctor?
Yeah, I think you're making a very important point.
Right.
And when we started this journey, that was one of the things we looked at. There is an entire system within the judiciary that is tasked, a task force that is tasked with the obligation to go out there, preach the gospel of ADR and mediation particularly, so to speak. And as you say rightfully, that where there is lack of information, because information abhors a vacuum.
Yes.
Some people will fill in information and will speak about the systems. I think the trend we are now seeing for the last 6 years is that incrementally Kenyans are embracing ADR. We may not be doing enough, and that is why some of us are now on this show, to educate Kenyans on the benefits of resolving disputes away from court. Number one, it is fairly cheaper. Number two, it is speedier. Number three, it repairs relations. You have just said about community relationships. Some of these disputes involve family members at a very close level. Business partners want to see that they can go back to their business and work as it was before.
Exactly.
So the idea of resolving dispute in an amicable environment, in an environment that you are comfortable sharing information, is what we are really talking about. Whether we are doing enough to promote the processes of ADR, particularly mediation, is a question that depends on many things, including finances, including the ability for us to market or speak about what we are doing.
Yes.
But we are doing all we can, using every medium, including newspapers. We have mediation weeks across the country where we speak to litigants in the morning before we start court to explain to them that you are in court, yes, but we have alternative multi-door processes that you can engage, which will be shorter, cheaper, and which are fully paid for by the government. By the way, the court annexed mediation process is completely free of charge. The mediators are paid by the government.
But perhaps that is one information that many Kenyans are not aware of.
And this is the proper place to say it, because this is the national broadcaster. Kenyans are watching. We will come to the radios. We will go to the chief barazas. We will go to court sessions, and we will tell people in social media and other media that, look, we have alternatives that are cheaper, that are faster, that are effective, that are efficient, where you can sit with your adversary, discuss your problem. Remember, when you go to court, you have to have a legal argument. In a mediation, you don't have to have a legal argument. All you need is a grievance.
Yeah.
I can say, my brother, you have offended me. If you apologize, we will move on.
Yes.
In court, you cannot just move away with an apology. Somebody has to pay another one. So when we are crafting this message to people, it is important that we tell them what the benefits are. It is important that we tell them where these processes are. And Kenyans are always very keen to know, how much am I going to spend? I'm already in court. I already have lawyers.
Yeah.
Why are you taking me back? That is what we started. When we started this process, those are some of the questions we asked. People were asking, I already have a lawyer. I already have a court case. Why am I being taken to mediation? And you'll be told, look, if you go to mediation, in 15 minutes or 30 minutes, a court case that has been in court for 20 years, 12 years, can be resolved. and you don't have to resolve it in the manner in which judges would resolve cases ordinarily. So again, I agree with you that we must do a bit better, but again, there are constraints, financial constraints. As you know, we operate within a system where there are deficits in budgets. We are doing our best using all the resources available to reach out to people. But when we hear that many Kenyans are still asking questions, 6-7 years after we piloted this program, we still feel there is a serious gap.
Absolutely.
Yes.
And to see what really happens, Muinde, is that in terms of mediation, a particular party would feel disadvantaged. Somebody will say that, well, we've gone through the process, but I feel like I've not gotten the justice that I really wanted. That is a bit of the disadvantage of mediation, if I may argue, right?
Yes.
So how do you resolve it?
Mediation, for one, it's a personal decision. No one forces you to mediation because...
It's now a basis of willing buy, willing sell.
Yes.
Yes.
Mediation is about individuals being willing to sit down and mediate. Because most of the time you find that there are also cases which are not mediatable. So people opt for litigation. So for that reason, in mediation, before people go for a sitting or a session, they have to agree on whether they want to mediate. Yes. Also, from Dr.'s point, he mentioned about maintaining relationships. I'll give an example of divorce cases.
Yes.
In divorce cases right now, we totally understand that it becomes very messy and it's not a very safe space to have your divorce cases in court. So it is always advisable to mediate your divorce cases because most of the time you'll have maybe the public and the media all over in court. So also nobody wants to air their dirty linen. So in mediation, you're given a space where you can be remorseful, you're seated with your partner, and you're able to solve your disputes in a very amicable way.
Absolutely.
Yes.
Can one refer an active case in court to mediation? If I have an active case and then, I go before a judge and say, Mheshimiwa, I'd love to take my case to mediation. Is that possible?
Absolutely, 100%. That is what is even encouraged under our rules in the court annexed mediation. There is a process of screening the cases. When you file your case, it is screened by the registrars. They look at the case and they see whether it is appropriate for mediation. Now remember, not all disputes are appropriate for mediation. That's come back to the question you've just asked.
Yes, which cases qualify for mediation?
Let me go there. Justice is a variable. Courts do not guarantee you any justice. Justice is a notion. It is something you feel that you have gotten justice. Some people even come out of court believing they have gotten an injustice. You have seen even in election petitions, some people who lost saying that was an unjust decision. But the question is this: when we are resolving disputes, how do we guarantee that the parties will feel that the process was fair?
Exactly.
Not necessarily giving the outcome they give.
Yes.
Now back to your question, whether you can refer an existing case to mediation. The cases are screened. You can voluntarily say, we want to park our case, try in mediation, then come back if we fail to resolve. But as I said, not all disputes will be referred. Criminal cases, for instance, justice must be served in criminal cases. You cannot just negotiate away a crime because it has a public policy element. If you have murdered somebody, you cannot come and say, I just want to negotiate and come out. Cases of rape, sexual assault, where there is a public interest to show that people are punished for crimes that they have committed. Some of those cases may not fit for mediation. So mediation is not an all-size-fits-it-all. It doesn't fit for every kind of dispute or every kind of judicial matter in court. But commercial cases, for instance, you have a land dispute over sale and purchase of land. Employment cases, for instance, family matrimonial disputes, succession cases. One of the biggest problems in our courts across the country are succession cases. You find somebody died in 1950, his sons have died in 1980, the grandchildren are now old people, still litigating the estate of their grandfather who died in 1950. So they have not even distributed the estate at that level. We are already on the 3rd generation of disputes, and we are now facing 100 people who are disputing over an estate of a man who died in 1950.
Perhaps that takes us back to the order the wheels of justice grind slowly, but ultimately they will come to pass. But then,
absolutely,
you know, there's that cultural bit that can affect mediation in some society. I mean, in some tribes in Kenya, for example. When you take a case of a rape case, for example, some people would sit somewhere under a tree and call wazee 2, 3 there, and they say, you know what, because you did this, we are going to bring 3 goats, and the case is settled. But when you look at it, rape is a grievous offense. How do we now start lifting such cases from mediation to the courts so that you know, all parties aggrieved seem to get justice? Because you've said, Daktari, that justice is a form of notion, it's a feeling that you get. But culturally, where do we draw the line between cultural beliefs and mediation and law and justice?
To begin with, rape cases are very difficult. And in mediation, if at all you have to handle a rape case, it may take forever to mediate it. One, a mediator is only an individual who is there to assist the parties,
yes,
in a skillful way, to be able for them to come out with a resolution for their matter. In rape cases, most of the time it becomes very difficult to mediate because both parties are not willing to complete the entire session.
Yes.
And that's why also Daktari has mentioned not all matters are able to be mediated. Rather, people opt for litigation. Yes.
I want to ask you this particular question because a majority of people who feel at some point disadvantaged are the female. You know, they feel that, you know, the society will look down upon us, so we'll have to hide behind the granary. That's what they say, behind the tent. Then we can have a mediation. Do you really think that women should now start coming out more openly and seek for justice, whether it is through mediation or through a court process?
Yes, because there are so many women out here who have been raped, and because of the stigma and maybe they don't want to be judged, they go silent for a long time. And also that also has created people becoming dysfunctional in terms of maybe in their social lives they're unable maybe to associate with men because the only mentality they have about men is bad. Men are rapists, men are all that. So I really would urge maybe all women out there who've been raped and who are looking for help should come out publicly so that they can get assisted. Yes.
You know, you talked about Article 159, and you know, when it was put there in the Constitution, the whole aspect of having the ADR and, you know, as an aspect of conflict resolution, many Kenyans are slowly accepting it. But let it remain at that particular point. So the question I want to ask you, Daktari,
yes,
at what point will the government fully call upon Kenyans to leave the court process and go for mediation? Because we still have backlog of cases running to hundreds of thousands, way back into the 70s and 80s, still active.
Let me say this. Access to justice, Article 48 of the Constitution, underscores that Kenyans must be given an opportunity to access justice in the various forms that justice manifests itself, including by using alternative justice systems and the traditional court system. Now, how is the government going to ensure that happens? We today have a draft national, we have a national ADR policy. The policy is meant to institutionalize the use of ADR at every level of government. One example, and I want to show you, is this. Every statute coming from Parliament now, establishing institutions, is making reference to ADR as a first port of call. You must go to ADR before you go to court. If you look at the English commercial courts now, in England, you will notice that now there is a mandatory mediation process being proposed before you go to court. Locally, we are saying that we want to create a multi-door approach in court. So this Chief Justice will very soon be speaking to this. And the idea is that when you file a case in court, when you reach the registry, you will be asked, have you tried mediation? one of the things you must check out before you file the case.
Right.
And you will be told there is a possibility of filing in mediation before going to court. So the court system will give you a multi-door. The new courthouses being built today have mediation suites as part of the architecture of the court. So you will be asked, okay, fine, you're bringing this case. Would you like to try mediation? We'll give you the mediation suits. We'll give you ready mediators before you come to court. For at least 30 or 60 days, try that before you go to court. So government is doing everything it can and doing the right thing because it is giving the infrastructure. We as institutions are now training mediators. We have over 1,000 qualified mediators in the court system today. When we started, I am mediator number 11. When we started 6 years ago, we were about 40 of us. Today, we have over 1,000.
That's a big number.
In another 2 years, we have more than 3,000. Yeah. Remember that you don't have to be a lawyer to be a mediator.
Oh,
you can be a mediator.
mediator.
You can train, and it takes 40 hours to train. And you can resolve media disputes, for instance. Disputes between media personalities, between social media influencers, for instance, people like who have contracts with the content producers. That is an area that is fertile for dispute resolution. And I'm saying this because the space has been opened. We have a mediation accreditation committee. You can now be accredited as a mediator so long as you meet the minimum qualification. And therefore the government is doing everything to make sure that we have mediators, we have a mediation process, and through the judiciary, giving funds to finance these processes. But that is not enough, because still, even with all these interventions, case backlog still persists. And one of the biggest problems is that Kenyans are very litigious, and they believe that everything
must go to court.
And when we have a dispute, it is we meet in court. Not understanding,
that's what they say.
Yes, not understanding that there are other options.
Yes. Okay, where do you see the future of Kenya in terms of conflict resolution? We have got ADRs now, and Dr. says that right now we have got over 1,000, and in the next few years, the number will shoot up.
Yes.
So what is your projection?
My projection is that in the next few years, I hope and believe that Kenyans will embrace alternative dispute resolution, mediation, or arbitration. Because by the end of the day, our economy slows down when we have backlog in court. We have a lot of money which is being withheld in court. And if at all we embrace mediation and arbitration, we'll have our economy moving forward. Yes.
Where is Kenya stand in terms of ADR when you compare with other jurisdictions? Because Kenya sits at a very strategic point in East and Central Africa. Where are we in terms of our justice system and our position in ADR?
I'll say that at least 60% of cases are able to be arbitrated and mediated, and the rest of the 40% should go to court.
Yes.
Because I believe more serious cases should go to court. I really tend to understand that you really don't have to go to court to take an individual to court because someone broke your glasses. Does it really make sense?
Yeah.
And the court also urges a lot of people to have at least, for you to go to court first, try and have your matters mediated before you opt to go to court. Because the court has a lot of serious issues pending. We have murder cases. You really don't have to wait for a very long time to have your case listened, and maybe you have a case only maybe whereby someone owes you only 10,000 shillings. That's why right now we have the small claims court. With the small claims court right now, those are cases below 1 million shillings. So instead of going to court and waiting for a very long time, the small claims court is helping individuals to get back their money if someone owes you money. So you can get it maybe in a short period of time, within 3 months, through the court.
Yes. Doctor, your take?
Yes. The future is bright. The landscape of dispute resolution in Kenya is evolving very quickly. For the last 10 years, Kenya is at the forefront. We have one of the few judiciaries in the world that have fully embraced ADR. We have judges who are leading, spearheading the ADR gospel. We have a Chief Justice that is committed to ADR, both the former and the current Chief Justice. We have committed money to paying mediators. The landscape is changing. This is one of the countries on the globe that has fully embraced ADR. And I think to answer your question directly, Kenya is in a good place in terms of developing justice systems. As you know, Kenyans are very, very creative. They are people who are progressive. So we do not fear evolving into the new generation of dispute resolution. So I see a situation where in the next 10 years, every lawyer, at least in this country, will have some idea, training or understanding of ADR. Judges have fully embraced ADR. Many of the judges are also mediators today and arbitrators. So I see a situation where in the next few years, it will not be a question of asking about mediation or ADR. It is the quality of ADR and mediation that we will now be speaking about. Because the infrastructure is in place, the fundamentals are already being put in place, the foundation is strong, and going into the future. And we have already started seeing that the backlog has significantly reduced because of this diversion into ADR. And on another day, we will speak about ADR in the criminal justice system.
Absolutely.
Plea bargaining and other forms of ADR that are being employed in that particular space.
But let me ask you, Wakili, when you look at it this way, don't you think that this will now water down the strength of cases that we have if everybody will now start going for ADR, running away from courts? We'll have, you know, they say Kenya is Kenyan. And some will tell you, you know what, instead of going to court, we are going to be charged this particular amount, give me this and know how we're going to square this. So we'll have very strong cases, but being swept under the carpet.
I'll actually
Is that a threat that you are facing currently?
To some lawyers, yes, it is a threat. However, we are having advocates who are being trained as mediators as well.
Yes.
We have firms who are having both mediation and arbitration.
Who are certified.
Yes.
Yes.
So it's really a 50-50 situation whereby they want to embrace it and they don't want to embrace it. However, work and money is still there. As we've said, mediation is a personal decision. You can never force parties to go for mediation. Also, the reason as to why probably people should at least embrace mediation, it's because it's cheap. You don't have to look for enormous amounts of money to get a lawyer. It's also not time consuming. So by the end of the day, lawyers win, mediators win. Yes.
Okay, Doctor, we have some funny lawyers outside here. Let me use the word funny in quotes. Are you one of them?
Let me say this. Every lawyer who is qualified, licensed to practice law is a person who has the very highest standing because we are regulated. But I want to answer your question by saying this. A new profession is emerging. A profession of mediators, adjudicators, arbitrators, away from the traditional lawyering. It's another revenue stream for lawyers. It's a revenue stream for other people. You know, in this country, we need more jobs created. So we are playing our part in creating jobs. But look at the US, for instance, and you asked a very good question. Will it water down the quality of our legal practice and jurisprudence in these areas?
Yeah, because when you talk about anybody can go to, you know, can go there.
Let me say this.
Kenya School of Law will not have students.
Let me tell you this. In the last 10 years, and I've been teaching at the School of Law, the number of students has increased. Not reduced. So there is a place for the traditional lawyer. There is also a place for the ADR practitioner. Just the same way we have social media, but we still have a place for newspapers. We still have a place for the TV. Even as we have YouTube, we have a place for the traditional TV.
Absolutely.
So everybody has a space. Even more importantly, looking at the example of the US, hardly 8% of cases get to court. People file cases, but hardly 8% get to trial. People resolve disputes by way of depositions and arguments at that stage. By just looking at what will happen in court, will you succeed or not? So most cases end at settlement. Why is that so? And it makes lawyers still earn money. Lawyers are not cheap. Mediators may be cheap. When you look at your dispute, when you have a dispute, for instance, with your employer, and you have an opportunity to settle it before you get to trial, and get 80-90%, perhaps even 100% of what you would have gotten, ADR has worked. So I want to say that I do not see any threat to any profession. or any person. There are many streams of the law. When I started practicing law about 18 years ago, there were very limited courts which you would go to. There were very limited causes of actions that you would pursue in court. Today there is IP, today there is social media, today there is data protection, and today there is energy law and oil and gas. So there is always the expansion of the law as societies develop. So I see no problem whatsoever in embracing mediation. In fact, if you ask me, I am now seeing people who have full-time mediators, full-time arbitrators, full-time construction adjudicators, people who have decided that they will not go to court, and yet they are trained to actually resolve disputes. Yes. And
when you look at, the judiciary, the formation and the format of the judiciary, accepting and now embracing ADR, at what particular point do you think that the judiciary should now give full mandate to the mediators and arbitrators to handle their cases without necessarily going to court?
I believe the judiciary has already given the mandate.
Right.
Having the court annexed mediation already gives the mediators who
it's clearly out there.
Yes, who are accredited. And also the judiciary has also played a very big role. We have court annexed mediation in different places. At first it was in Milimani. I believe it was channeled in 2016. And also right now we have the court annexed mediation in different counties. We have one in Kiambu, I believe another one in different places in the country right now. So I believe with the judiciary, it's a safe space for every other person, and they are allowing people to mediate. Yes.
What are some of the challenges generally? Because at the end of the day, you'll have two parties coming at a round table, but what are some of the challenges even in effecting this?
The challenges come in whereby maybe the parties have not yet agreed on whether or not they want to mediate. I, as a mediator, I have the capacity and the skill to enlighten them on why they should embrace mediation. And also, before you start mediating, you always have to ensure that you tell both parties on the importance of mediation, why they should embrace mediation. So through the process of mediation, because I'm not supposed to be involved in the mediation for them to make the decision. I'm only there to assist them and only give them a guidance on how they have to have the process move forward. So with that, maybe the parties come up with way on how they want to move forward with their case.
That's right.
Yes.
Take it.
Not all that glitters is gold, and not every human endeavor is perfect. We are a work in progress. We cannot say that mediation works completely, but we can say it works most of the times in many situations. When should the judiciary hand over mediation to the people? Remember, one of the paradoxes here is that you have a court system that is saying go elsewhere, and yet we have established it to actually deal with cases. It is really for this simple reason that the court, in the orbit of dispute resolution, the court is at the center, like the sun is in the orbit, so that you have all the other systems running around it. What is critical to understand is that we are dealing with a cultural issue. People trust courts. That is the institution of government that they know resolves disputes. So it was the most convenient place to start this process, because when people come to court and they are told go to mediation, they feel a bit more comfortable, confident. Thirdly, state can only fund some of these processes through formal systems. So if the government is giving money for mediation, it can only come through a system, either the Attorney General's office or the judiciary. So the judiciary took it upon itself. But the truth is that ADR does not belong to the judiciary. The court is playing its role. It may actually be one of the significant roles, but ADR also exists outside the court. The court only helps us to make it cheaper, accessible, gives us the infrastructure. But nothing stops people from conducting private mediations, from conducting private dispute resolution by negotiation and conciliation and other means. But what I have seen is that when these dispute resolution mechanisms go outside the court, they tend to become more expensive, because the court and this government system regulates what can be paid and who pays and how much. And many Kenyans are still struggling. They are indigent. They have spent their money on lawyers. They have filed court cases. They do not have the extra coin to pay a private mediator. So I think in the long term, being a developed country, this is where we want, a developing country, this is where we start. As we develop into a middle income economy and maybe perhaps do better, we may just allow it naturally, organically, you know, generically to go into its own place. Like water, it will find its place.
It will find its place.
Yes.
What are you doing as, you know, it's a stream of lawyers to reach every part of the corner of this country, at least to spread the word? Well, the government will do its part, but, you know, as mediators, as lawyers in the country, what are you doing in your own capacities to pass that message across?
Well, to start with, a vice chair, a Thika Mediation branch. With the help of Honorable Stella Tambo, she's our patron in Thika Mediation Center. With my team, we were able to launch, that was last year, and we had a few people through the judiciary who came in, and we were able to come up with a bit of solutions to see on how we are going to enlighten and market mediation in Thika and Kiambu. Also, we are able, through maybe those WhatsApp groups and every other platform, Facebook and every other platform, we are able to educate people on mediation. And also through our mediation center, we are able to train people, and through that, at least we are able to reach a few people within our region. Yes.
How can somebody, you know, go through the mediation, the process of, you know, okay, fine, I want this case sorted out of court. So how does one start the process until the case is settled?
First off, we have private mediation, and also we have the judicial, the court annex mediation.
Yes.
So if you're a private mediator, maybe how do people get you? Probably
or somebody can just walk to court and say, you know what, I have a case, and get me one mediator here.
Through the court, they have maybe the accredited people. So through the people who are accredited, they are able to maybe choose one mediator or two. Then maybe the parties who want to mediate are able to pick one, so they can go through the entire mediation process. Yes.
Doctor, do we have geographical influence in terms of a particular region of this country has so many cases that should go through arbitration and mediation compared to other regions?
Yes, let me start by answering your previous question, what we are doing.
Yes.
What we are doing, for instance, at the Chartered Institute of Arbitrators, our mandate is to promote ADR. The Chief Justice is our patron. What we have done is to take every opportunity to speak about ADR. We carry out sensitization. We have conferences. There is one coming in July. We are inviting you.
Thank you.
We have an ADR week, a whole week where we discuss, disseminate information to members of the public on ADR. We have one coming in April, and the theme is Africanization of dispute resolution.
Here in Kenya.
Remember, mediation here in Kenya, Nairobi. Remember, mediation is really African. That is the way we resolve disputes. Courts came to us about 130 years ago. We did not have courts. These English courts with wigs and judges pronouncing themselves are new to us. We are still adapting.
In this case, we'll go back to our normal selves, you mean?
Yeah, we are actually back to default settings, which is to resolve disputes by discussion, by having facilitators, and not necessarily an adversarial system. But to answer your question, what do we do when you want to? Sometimes you can go to court and say, I want my dispute resolved by mediation. They will give you a roster of mediators, and you'll choose from them. You can also look for a mediator yourself, a private mediator. Come to a person like me or her, approach us, and then we can resolve the dispute for you. That is permissible. Then the agreement can be registered in court and enforced as a decree of the court. Yes.
Okay, I want to give you your final remarks, because at the end of the day, in 10 years to come, the backlog of cases will, of course, reduce based on, the speed at which the judges will be taking the files and clearing them one by one. So what are we looking at in the next 10 years? Mediation is going to take shape. With 1,000 membership rate now, it means the number is going to go up. So what do we look at? And, when you look at the judiciary now, the Chief Justice is actually now trying to roll out and open many courts across the country.
Yes.
What is your projection in terms of the court cases 10 years from now?
First, I'll want to tell Dr. I'm also a student at CIArb.
Oh, right, good.
I'm actually supposed to be doing my module 1. I think it's maybe in April, March, about. Yeah.
Dr. Remember.
My final remark would be, in the next 10 years, I believe that we'll have already been in a very strong position to ensure that we have a stable society whereby people don't have to go to court to solve their disputes. We also, as a country, we need to have emotionally stable human beings, because we believe that going to court, it's really not the easiest thing. Standing there, it's normally not the best feeling. But in mediation or in arbitration, you're comfortable, you're able to air out your grievances, you're able to be listened to, and you're comfortable. So by the end of the day, when you get out of these sessions and you feel like life can move on. Yes.
All right. Dr. Your final remarks?
My final remarks, justice, there's that old adage, justice delayed is justice denied. Everybody is looking for quality justice at a good cost and quickly, expeditious, cost-effective justice. And we must all play our small parts. We are playing our part as the Chartered Institute of Arbitrators. The judiciary is playing its part. The government is playing its part. We can all do better. We are urging the media and other Kenyans to also play their part. Invite us in some of these forums. We will also invite you in some of our spaces to highlight what we are doing. Because at the end of the day, without information, people do not know what is happening. Invite us, play our part. Not only political shows and other shows. These are the things that really matter to Kenyans. Because Kenyans
consume politics.
But they do not go home with politics. They have disputes over their land which they live in. They have employment cases. Those are the things that really matter to these people. So let's have a balance of these things and have opportunities where we can talk about what really matters to Kenyans. But I think as far as we are concerned, there is progress, and the progress is positive. Kenyans are embracing change. Kenyans are also embracing alternative justice systems. And I think going forward, we see a brighter future.
Absolutely.
In another 10 years, one thing I know is that we will have a justice system that mirrors the culture of Africans, our Kenyan culture. We will have court systems that work, and according to the Chief Justice in our social transformation program, we hope to see that all cases are resolved within 3 years, whether you come from the High Court or magistracy all the way, so that you don't have to wait for 10, 20 years for your case to be resolved. You have options available. Thank you.
Syokau, one of my directors said that she has a problem. Can you mediate? My director is saying in my ears that he has a problem. Can you mediate?
Yes, I can. I'll give you my number one time.
Martin, you have a mediator here. Please, we know your problem. All right, thank you so much.
Here.
We've been speaking matters justice. We've been talking matters justice, Kenya foreign relations. As far as the viewpoint today is concerned, we thank you so much for being a part of this show. We've been speaking to Syokau Muinde, who is a lawyer and certified arbitrator, and Dr. Wilfred Mutubwa, who is a chartered arbitrator and chairman of CIArb Kenya, talking to us here. Please, if you have any case, instead of going to court, arbitrate. We have got brilliant heads here, all right? Now we have them on set. Thank you so much for being a part of the show. Good morning. My name is Victor Oloo.